Hi, Derryl. I thought I'd just do a short presentation on being a legal expert. So, what's a legal expert? The literature suggests that occupational expertise is somebody who is effective in identifying and responding to novel problems within a particular domain of knowledge, such as an occupational practice, such as law. That is, it is domain specific. It's not just about a person's cleverness, their ability to manipulate knowledge, but rather it's characterized by having a profound body of knowledge and being able to use that to address non-routine problems, such as in legal cases. That domain might be broadly like law, but it's most likely to be a particular body of law, such as commercial, criminal, or whatever kind of law, and likely within a particular jurisdiction, international, federal, or state and territory, because that is where the practice will occur and that is where people's knowledge will have developed. Most likely, there is no such thing as a legal expert practitioner per se. There's no such thing as a particular expert in the area, but only within the specific domain of law practice. So what's this expertise founded on? It's most likely founded upon the possession and interdependence of three kinds of knowledge. Firstly, deep domain-specific conceptual knowledge, and that is beyond simple having a lot of factual knowledge. It's the depth of understanding about the relationships amongst facts, concepts, and propositions and how they might be used, for instance, in diagnosing cases or in legal and medical diagnosis, for instance. Then there is the strategic procedural knowledge, and that's a skillfulness associated with appraising the particular situation, considering and evaluating options, and judging the most possible, viable, or expedient for a situation. And again, from healthcare, the notion of differential diagnosis. But that's also underpinned by dispositions such as interest, diligence, ethical conduct, and being openness to alternatives associated with that domain. So how do we develop these capacities? Well, ultimately, it's a combination of experience over time and engagement that is likely to be required. Firstly, having a strong foundation of conceptual and procedural disposition knowledge through perhaps initial study, going to law school, but also through practicing law would be important for developing and refining the concepts and procedures and developing a dispositional approach, what the person's interested in and what drives their engagement. And then experiences within that field or across subfields that will develop a personal domain of knowledge based upon those experiences. Over time, this requires effortful engagement by the individual to construct and organize and exercise what they know, can do, and value. So that effortful engagement is important. This learning doesn't happen simply by participating in legal practice. It's about the quality of engagement with it. And what we know, I think, is that episodic experiences over time that expose and engage individuals in the complexity, resolution, and evaluation of demanding tasks, such as legal proceedings, is important. So this kind of experience isn't just 30 years of legal experience. What it is engaging in different kind of cases, also having the ability to follow cases through across from the beginning of the case through to its proceedings and its resolution, and then some appeals or making sense of that. So these seem to be the key ways in which these capacities are developed. I hope this is useful in some way.